Summary of Consent to Act, NRS 645.252, subparagraph 1, subparagraph D. Nevada law allows a broker to represent more than one party in a real estate transaction. The same person or entity may act as the agent for two parties interested in the same transaction when their interests do not conflict and where loyalty to one does not necessarily constitute a breach of duty to the other. When representing more than one party in a transaction, the broker must disclose this representation and obtain written consent of each party before proceeding. The form is divided into approximately 7 parts. Parts 1 and 3 are informational, giving the property address, licensee's name and license number, brokerage, sellers, and buyers' names. Part 2 recites the legal authorization that allows a broker to act for more than one party in a real estate transaction and states the requirement for written client authorization. Part 4 identifies the licensee's conflict of interest, the duty of confidentiality, and the requirement for each client to have also received a duties owed form. Part 5 lets the client know he or she is not required to consent to this type of representation. Part 6 is the client's acknowledgement of receipt of the form and a statement that consent is being granted without coercion. Part 7 is the client's signatures box. The disclosure form, called Consent to Act, outlines for the client the consequences of the licensee's multiple representation and requires the client's written authorization before the licensee may proceed with such representation. The Consent to Act form is designed with the seller/landlord and buyer/tenant relationship in mind. Regardless of which parties are being represented, each party must be given a Consent to Act form and the opportunity to reject this type of agency relationship. The information provided above is not legal or tax advice. You should consult with a professional of your choice regarding any questions or concerns before its execution.